so much. Thank you so much for coming to today's event, Laboratories of Change, State Initiatives for Affordable Medicine, that is co-hosted by the Center for Health Policy and the Law at the O'Neill Institute, which I work at. My name is Zach Barron, along with my colleague Andrew, co-directors of the Center for Health Policy and the Law. We're so excited to be able to co-host today's event with IPIP, the Intellectual Property and Information Policy Clinic here at Georgetown Law, as well as with the university's Allied for Essential Medicines. Just briefly, the way that this event is going to work is we are going to have some presentations where folks are going to kind of walk through different slides about the policy and legal landscape in terms of different state initiatives for affordable medicine. And then there will be opportunities, a panel with Q&A at the end. So I think now we will turn it over for our first presentation. Sheila.
Hi, everyone. My name is Sheila Ranganathan. I am with the Center for Health Policy and the Law at the O'Neill Institute, and I'm really excited to be here with you all today. Next slide. So by way of introduction, our center provides legal technical assistance to policymakers, litigators, reporters, and the general public on how the courts are shaping health law and policy. Next slide. So we maintain a litigation tracker that has more than 200 cases. It's a free resource with all of the briefings for these 200 federal court cases. And we stay up to date with all the big updates. We provide high-level trends and implications of all of these cases through articles and presentations, just like this one. And we're currently adding a lot of cases, about a dozen on prescription drug pricing challenges to our tracker right now, and I'll be discussing them as we go along. So most of today's event will focus on state initiatives and challenges to those state initiatives, but I'll also be giving a quick overview of some lawsuits at the federal level because a lot of the claims at the federal level mirror a lot of the challenges that we're seeing at the state level. We'll then also look at state laws that are aiming to address prescription drug prices and then how those challenges are faring in court so far. And then lastly, we'll do a deeper dive into Colorado's Prescription Drug Affordability Board law and Amgen's ongoing lawsuit that is trying to block the law. So quickly setting the stage, why are we here today? In terms of access to care, the high cost of drugs can really disrupt patient care and lead to worsening health outcomes. 3 out of 10 adults have reported not taking their medicines because they were too expensive, and failure to take medications results in exacerbating pain, making chronic conditions worse, higher hospitalization rates, higher utilization of care, and overall higher costs in the healthcare system. This disproportionately burdens low-income people, which are often communities of color, and people with other chronic and really severe medical conditions, and so it's also a health equity problem. High drug costs impact the state and federal government as well because both are payers in the healthcare system. They spend a lot of money on drugs, which also diverts resources away from preventive and other kinds of care. And given all of that, it's really clear that we need more solutions at the state level and the federal to address these issues. So again, I'm starting with federal law and litigation to give an overview of the broader landscape of drug affordability, but also just to situate you all that whenever we see laws that attempt to bring down the cost of prescription drugs, we will see private attempts to litigate them. We will see first pharma trying to lobby and use other methods to stop the law from getting passed in the first place, but then we'll also see them in the courts, both at the federal and state levels. The pharma industry is very litigious, and manufacturers have been using coordinated strategies over and over again to attack these solutions in every way that they can. And we expect these aggressive challenges to keep going on and on every time we try to implement a new solution. So in case you aren't familiar with the Inflation Reduction Act of 2022, the federal government implemented this law that, among other things, allows the federal government to negotiate the price of drugs for the Medicare program. So there's an extensive negotiation process set out by statute and implemented through regulations and guidance. Manufacturers can choose not to sell drugs to the government, but they also can choose to participate by engaging in the negotiation process. The program is projected right now to save Medicare at least $6 billion on prescription drug costs, so it's very significant. And of course, manufacturers sued to block the law even before the program went into effect on both constitutional and administrative grounds. So currently there's 9 ongoing challenges in the federal courts across the country. As you can see here, manufacturers have brought a slew of constitutional and administrative claims. So far, every district court has ruled for the federal government and chosen to uphold the Inflation Reduction Act. But many of these opinions are also being challenged at the appellate level now, and so we'll see how that goes at the appellate level. Another issue at the federal level is improper patent listings in the Orange Book. So FDA maintains this resource called the Orange Book, which lists out all of the drugs that are approved by FDA to be marketed in the United States. And it includes information about the drugs, about FDA's evaluation of the patents and approved generics, information about regulatory exclusivities that might prevent a brand name drug from having any kind of generic competition in the market. And it also has certain rules about what patents can and cannot be listed. And most importantly, to get a generic into the market, you have to make sure that there isn't a brand name drug that's in the Orange Book for that drug. And FDA doesn't independently verify what manufacturers are submitting to go into the Orange Book. And so they're basically relying on an honor system there to make sure that the information is correct to a pretty great extent. And in 2023 and 2024, the Federal Trade Commission found that over 400 patents were improperly listed in the Orange Book, blocking entry of many generics. Next slide. And so there are many private challenges happening right now where manufacturers are challenging other manufacturers to basically sue, saying, we want to bring our generic into the market, but we can't do that because of your improper patent listing. And now the FTC has gotten involved by submitting amicus briefs in a lot of these cases. Okay, so the main topic today is how states are acting as laboratories of democracy by designing and testing out various ideas, seeing how the pharmaceutical industry reacts to them, and then potentially figuring out how to help other states and the federal government apply those innovative policies. Next slide. So there are 4 types of state laws that our team has been tracking to address the cost of prescription drugs. And all of these categories specifically address the wholesale acquisition cost that is set by the manufacturers. So we have reimburse or resupply laws, transparency requirements, price gouging laws, and prescription drug affordability boards. And we'll be going into examples of these laws as well as some challenges that we've been seeing in federal court. So the first one, because EpiPens are critical to people with severe allergies and are very expensive, Colorado enacted this law to basically limit the cost of EpiPens for consumers. And so they decided that they were going to ensure that people didn't have to pay more than $60 for a 2-pack of EpiPens. In order to implement that, they said, okay, if you are insured, you pay $60, your insurance company pays the rest. If you're uninsured, you still only pay $60. But the way that they did this is that pharmacies would then basically take the burden of that, but then submit a claim to manufacturers and ask the manufacturers to either reimburse them for the amount that the pharmacy lost or get a resupply of how many EpiPens they gave to uninsured consumers. So this is an example of a reimburse or resupply law. There were really high penalties for failure to comply of $10,000 every time. And then this would also fall under Colorado's deceptive trade practices law, which could be further subject to more penalties. So of course, Teva, a manufacturer of EpiPens, challenged the law 3 months before it was supposed to go into effect, arguing that this was an unconstitutional taking of its property. Slide. So at the district court, the judge was sympathetic to Teva, finding that the law does effectuate a taking. They didn't block the law at the preliminary stage because they said, okay, under the law, if there is a physical taking by the government, we need to see if there was just compensation to the person that the property was taken by. So TIBA was arguing that the way that the law is structured, we would have to litigate the state every single time that we wanted to get just compensation for how much ever we had to reimburse and resupply. And that would be impractical, inefficient, and it would hurt us. And so they were saying, no, this is an unconstitutional taking. And the district court judge was basically like, maybe we're not ready to rule on that yet. So that is the issue that is up at the 10th Circuit now, but that litigation is still ongoing, and we'll see how it fares. But basically the open issue here is whether the taking was unconstitutional or not, but we know now that judges seem to think that this is a taking regardless. Next slide. Another kind of law, transparency requirements. So Oregon passed a law requiring manufacturers to report certain information if a drug that they sold cost more than $100 for a month's supply, and there was a 10% increase in price over the course of the year. So basically, if the drug is expensive and you increase the price even more, you have to submit certain information to us. And that information basically included the name of the drug, the price, the increase in price, how long the drug's been on the market, the reason that the price was increased, whether there were generics available, how much it costs the manufacturer to make and sell the drug, how much the manufacturer gets per year, and how much the drug costs in other countries. So a whole lot of information that manufacturers usually don't want to give up. And then the law also required state agency to post this information online unless the information was considered a trade secret and the public interest didn't require the information to be posted. So there was like a balancing challenge there. Next slide. Again, pharma brought a lawsuit challenging the transparency law, bringing 4 different constitutional claims. And the district court did agree with its takings and First Amendment grounds, and so decided to block the state law as a result. This is also being appealed at the 9th Circuit, and a lot of states, including DC, have filed an amicus brief in support of the Oregon law, saying we really need this information to be able to create policies that address prescription drug pricing. Next slide. And then the last kind of law that I'll cover today are price gouging laws. So many states are attempting to constrain excessive price hikes for specific drugs that were dispensed or administered or somehow made available in the state. And that's what Minnesota did here in 2023. This sort of law targets this specific law targets off-patent and generic drugs that were sold, dispensed, or delivered in Minnesota, which means that the transaction might have happened out of the state, but as long as the drug eventually ended up in Minnesota, the manufacturer was supposed to comply with the requirements. There are various benchmarks in the statute to define excessive price increases and, again, large monetary penalties for noncompliance. As we've seen, the Association for Accessible Medicines, which is actually a pharmaceutical trade group, despite the sound of the name, filed a lawsuit to stop the law from getting enforced. Next slide. Again, here, the district court granted the preliminary injunction, meaning that the state law got temporarily blocked early on in the lawsuit while the lawsuit proceeds. Here, the court agreed with AAM's Dormant Commerce Clause claims, basically saying that the Minnesota law regulates transactions that are happening totally out of the state and have nothing to do with Minnesota transactions themselves. And so this was an unconstitutional violation of the Dormant Commerce Clause. The court also found that manufacturers could face significant penalties under the law of up to $500,000 if they tried to make sure that their drugs weren't going to end up in Minnesota. The court basically said that, businesses have the right to avoid doing business in a state if they don't like the laws in that state. And so these penalties are unfair and unconstitutional. And so yet again, manufacturers figured out how to challenge the law on these technical grounds, and were able to evade the purpose of the law, which was to stop them from excessively increasing their prices. And I'll now turn it over to my colleague Isosa to chat more about PDABs.
Can everyone hear me okay? Hi, everyone. My name is Isosa Osagai, and I'm also an associate at the Center for Health Policy and the Law. And I'll be doing a bit of a deeper dive on prescription drug affordability boards and one of the cases we've been following around PDABs. So as Sheila mentioned, one of the tools that states have started to use to address the issue of high drug costs is prescription drug affordability boards, or what I'll be calling PDABs. And what they'll do is essentially establish legislation that gives these boards the authority to determine whether drugs are unaffordable, and then usually establish upper payment limits on the reimbursements that can be received for these drugs. The states highlighted in green up here are states that have enacted or are considering enacting some form of a PDAB. Some of them are considering giving the board the authority to determine what drugs are unaffordable and then establish upper payment limits. A handful of them are giving the authority to do the first thing, determine they're unaffordable, and then consider a whole host of other cost containment strategies. I'll be going specifically into Colorado's PDAB. Thanks. So in 2021, Colorado enacted legislation to establish their own PDAB, and this gave the board the authority to determine what drugs are unaffordable, and then again, establish upper payment limits on the reimbursements that can be received for these drugs. And listed up here are some of the different actors that these UPLs are meant to apply to. Earlier this year, Colorado's PDAB found a drug called Enbrel to be unaffordable. And soon after that, Amgen, the manufacturer of Enbrel, filed suit against Colorado's recently established board. And I'll be going into each of the legal arguments that are raised by both parties. So first, there's the issue of standing, and standing is basically just the question of whether or not a party can actually bring a case. And to establish standing, a party has to show that they have been harmed or injured by the opposing party's actions, or that they're likely to be harmed or injured by the opposing party's actions. Colorado in this case is saying that because the UPL would apply to actors that are sort of downstream from Amgen and not directly to Amgen as the manufacturer, that Amgen does not have standing in this case. Amgen, on the other hand, is saying that, and Colorado is also saying that because the UPL hasn't been established, that's another reason they feel like there's no standing there. Amgen, on the other hand, is saying that they feel like it's very likely that a UPL will be established, and they feel like once it is, even if it is applied downstream, that they feel like it's going to lead to lower reimbursements throughout the supply chain, and that those losses will come back up to them. The next argument is on the issue of preemption, and preemption is essentially just the idea that where there's a conflict between state and federal laws, federal law is supposed to govern, or in other words, state law is preempted. Amgen's argument is that the PDAB law interferes with the aims of federal patent law, and they're saying this because they feel like patent law is supposed to reward innovation and everything else that comes with developing a new medication with a period of patent exclusivity, and does result in kind of like rights to determine prices that are reflective of that. And they're saying that the PDAB law prevents them from setting prices that they feel are reflective of this. Colorado, on the other hand, is saying that once Amgen makes that initial sale as the manufacturer to either a wholesaler or a distributor, that they exhaust those patent rights and that they've reaped the rewards for their innovation. Separately, they're saying that as a state, they have both a duty and a right to protect their citizens and the health of their citizens by regulating to address affordability of drugs. The next argument that Amgen is raising is on the issue of due process. Due process basically just requires the government to follow fair processes or procedure before taking protected right or interest. Amgen is saying that they have a protected property interest, specifically in the right to determine or dictate the prices at which Enbrel is sold. They're also saying that there's unfairness in the way that the board is structured. They're saying that the lack of clarity in the guidance that is issued by the board each time a determination is made gives the board kind of unchecked authority. And they also feel like there are no standards or guidelines listed within those that are meant to ensure they have a fair and reasonable return on their investment. And lastly, they're saying that they feel like there was no meaningful avenue for them to make these concerns be heard. Colorado, on the other hand, is saying that Amgen has no property right in, the right to sell Enbrel at a specific price. And they're saying that the guidelines and the sort of their reasons for the decisions and the determinations they make are given in detailed reports for each decision. And they're also saying that they're not required to necessarily formulaically spell out why each determined or how exactly each determination was made. And lastly, they say that they gave Amgen plenty of opportunity to engage with the board and make these concerns known through either commentary or board meetings that were held by the board. And the last argument that they're raising, that Amgen is raising, is a dormant commerce clause argument. The dormant commerce clause prohibits states from passing laws that unduly burden or restrict interstate commerce. Amgen is saying that because when a UPL is established to whatever downstream actors, it eventually comes back to them. They feel like a UPL basically has the same effect as a direct regulation of interstate commerce. And they feel like the burden that this places on interstate commerce also outweighs the benefit of the PDAB law. Colorado, though, is saying that the dormant commerce clause is not just kind of an open invitation to invalidate any state laws that have any impact on commerce outside of the state. And they're saying that the main kind of aim of Commerce Clause is to protect against sort of the idea of protecting in-state commerce from out-of-state competitors. And Colorado is saying that's not what we're doing here. We're not concerned with anything outside of Colorado. We're trying to regulate for our citizens. And I think just a note, the due process and dormant commerce clause arguments are, again, as we saw in some of the cases Sheila shared earlier, these are arguments that are coming up over and over and being used by pharmaceutical companies against states in these drug affordability cases. So as far as this case goes, both Amgen and Colorado have moved for summary judgment, and oral arguments were held at the end of October. At these oral arguments, the judge gave some pushback on Colorado's arguments on standing, specifically on their assertion that establishing a UPL is required for Amgen to establish standing. There were also some questions around Amgen's preemption and due process arguments, and those specifically were resting on Amgen's assertion about the property interest and the ability to set the price of Enbrel. So it's still kind of to be seen where these arguments land. But so far, at least on a federal level, that property interest that they're claiming they have hasn't been recognized on a federal level. So just to touch on a few key pieces that both Sheila and I mentioned. Next slide. So I'll start with the federal level. The IRA has been working to bring down drug costs, and while these savings are significant, the program is only for drugs under the Medicare program. But the federal government has been mostly successful in defending the drug price negotiation program in federal district courts. As for the Orange Book, manufacturers are engaging in practices like listing improper patents in the Orange Book to block generic competition and keep their profits high. And what generic manufacturers are doing is using litigation to attack these improper patent listings by brand name manufacturers. And the FTC's warning letters and amicus briefs have also led to the removal of many of these improper listings. And this hopefully leaves room for more generics to be entered, and this could significantly bring drug costs down. As far as the state level, I think seeing that high drug costs, the role that high drug costs play in worsening health outcomes, states are coming up with more and more creative solutions to increase access to drugs for low-income consumers, to require manufacturers to be more transparent about their price increases, and to limit price gouging. As we've been saying, drug manufacturers are extremely litigious, and this means that a lot of the state laws that we're seeing, or that we will see, get challenged through lobbying and litigation before they're ever even passed or implemented. Many of the claims that we're seeing over and over are going to be the takings clause arguments, due process and dormant commerce clause, as we said earlier, First Amendment, and federal preemption arguments. And lastly, there's very little case law on these state laws that we've discussed that address drug costs, and judges are therefore hesitant to create new precedent in this space. So it is hard to kind of say how these cases are going to come out. So just a few lessons from the state challenges that we've seen so far. As far as the reimburse and resupply laws, multiple courts have found that these laws are per se physical takings by the government. And the important question here is whether there is just compensation to manufacturers for the taking. And what we're seeing is that the option to litigate for compensation might not be enough. When it comes to the transparency requirements, dozens of states have implemented types of transparency requirements, but the information they seek is useful, but such laws usually face preemption claims about trade secret protections and First Amendment and dormant commerce claims. In the price gouging space, states are attempting to restrict manufacturers from excessively increasing costs of drugs that are sold, distributed, or dispensed in the states. And courts are finding these laws to impermissibly regulate completely out-of-state transactions under the Dormant Commerce Clause. One court also held that federal patent law preempts laws that attempt to set or cap prices for brand name drugs. And lastly, to bring it back to the PDAB space, Colorado was the first state to actually implement its PDAB law and select a drug for its affordability reviews. So as expected, the law was challenged, but no court has dealt with PDABs before. So I think a lot of states are going to have their eyes on this case, as well as the pharmaceutical companies, but it just remains to be seen how these arguments are going to be handled. And I think the hope is just that as these cases progress, they're at the very least instructed on how states should proceed in trying to make prescription drugs more affordable for their residents. And that's all.
We come in uniform. Awesome. Forgot the cover. Right up the 10. It's my slide first, right? All right, we can go to the next slide. Yeah, I'm telling that too.
We're ready for the next slide deck. Yeah, thank you.
Oh, there it is. Awesome. Oh, back one. There we go. Hi, everyone. My name is Justin Mendoza. I'm the Executive Director for Universities Allied for Essential Medicines. We are a nonprofit organization founded in 2001 at Yale University. And just by a quick show of hands, who here is a law student? Excellent. So we were actually started by a first-year law student. Her name was Amy, or is. Her name is. Whoa. Anyway, her name is Amy Kapczynski. She's now a professor at Yale Law, teaching in the Yale Global Health Justice Partnership. But in 2001, Amy had just traveled to South Africa. She had just learned about the price of HIV/AIDS medicines at $10,000 per patient per year. She had just connected to Doctors Without Borders and heard about a crisis treating HIV/AIDS at the cusp of the millennium. I just recently watched Rent a couple of weeks ago in a local high school production and was reminded of AZT, the treatment that was the standard at the time. And Yale had invented the Zaret, or Stavridine as the generic name, or D4T if you want the chemical compound. That drug had been patented at Yale, had been invented actually in the 1980s, made it to the market in the early 90s. It becomes the standard for treatment until we later discovered, much later, that it's not the safest course of treatment for HIV. And at $10,000 per patient per year, the response globally was to say that we could never treat HIV/AIDS anywhere in the world where there were low-income populations. Right? We just gave up. In 2001, when Amy and other students at Yale, as well as MSF and other folks, started to realize that this was something the university had stepped in and actually developed, they started looking at how did this product developed on campus get patented and have a monopoly and be sold to a company in a way, or licensed rather, to a company in a way that made it so expensive. And they started looking at that agreement. The scientists who invented the drug started writing in New York Times, and we started to build momentum. In that same year, Yale actually renegotiated their deal with Bristol Myers Squibb, signing a brand new licensing agreement, one that allowed generic competition. It allowed a company from India to step in, Cipla, to step in and start manufacturing their own version of the cocktail of AZT and start selling it to low and middle income countries around the world for just $1 a day. Over the course of the next few years, that price dropped to just $60 per year and started the change that we see today in terms of treating millions upon millions of HIV/AIDS patients around the world. I give that story from 25 years ago, though, which is an exciting story that kind of started our movement, because it proves that if you can address the business dealings of the pharmaceutical industry, if you can challenge some of the ways that medicines are priced or changed, you can make medicines affordable and accessible. And even more importantly, students led that movement. Students created that change. Students built the organization that has been fighting for the last 25 years to make that systemic. And still today, what we do is we work with universities all across the world, more than 30 of them, to bring in different policies and components. Work with 30, we're challenging more like 100, to bring in different policies and components that we think can change licensing agreements as they stand. We look at the intellectual property filed at university levels and we go from there. Frankly speaking, although we do sometimes weigh in, and actually seeing the presentation for our colleagues here today, I was watching that and remembering that, oh wait, I've worked on those transparency bills. I remember the Oregon bill conversation. I remember conversations about the Prescription Drug Affordability Board and some of the other pieces. But by the time we get to the point where someone's regulating the price of a drug, we believe we've already failed. If we could start at the very beginning, when you develop the product, do the underlying research, and set up the business agreement at the front and make sure that affordability is built in, we can fundamentally change healthcare when it comes to prescriptions and medical devices across the world. And the proof of concept was with AZT, and we've done it further on tuberculosis treatments and other medicines over the years. And we are at the point now where, looking at future innovations and what can be done, it's time for a little reimagining about how we can push the holders and the innovators upstream in the biomedical universe to really start thinking about what those agreements mean, what their contracts can do, and how we can make medicines affordable for the next generation of people. So that the next 15 to 20 years, we're not battling with trade associations in the courts, but we're just looking at the success we've had treating disease in the poorest places on earth. That's our vision, that's our mission, and we're made up of organizations and students from all over to try to fight for that. And we've had the pleasure of partnering with IPRIP now for the last 2 years to really start to build a little bit more of the kind of legal policy and understanding, and even informing how our strategies can move. Last year, we had a wonderful team, Tess is here from the team, and we were able to build a white paper and a guide on how to engage your university with FOIA requests and other freedom of information requests and other informational tools, as well as backgrounders on the legal landscape that sets up the entire university licensing space, at least in the United States. And that tool is already being used right now by about 15 different university chapters across the United States to really start building and going and kind of seeing what we can do to pressure their university administrations. And this year, we've had a great chance to work with this team, and I'm not going to take away anything from your presentation. But we'll hear about the new innovations that we think we can move forward and start to push in the landscape right now. I do have to say one thing that is related to, of course, political landscapes changing and where things are at now. That's all I'll say about that in general in a nonpartisan space. But just to say that with political landscapes changing, we have to look. It took about 20 years for the Inflation Reduction Act's language on Medicare negotiation to become viable. I know because I testified before Congress in 2019 pushing for Medicare negotiation. And the only people in that audience were one political party led by only Senator Bernie Sanders. We changed that to something that could actually pass within that party over a couple of short years, but it took 20 years to get there, well, 18. And these fights can take a long time. Pharmaceutical industry spent $373 million lobbying against the Inflation Reduction Act the year that it was passed. Our entire organizational budget is $270,000. You might notice a difference. When you start to build that out and think about what it takes to win these battles, it takes rooms full of smart people, rooms full of innovators, rooms full of folks who are actually organizing and mobilizing communities all over the place. We mobilize students, faculty, researchers. Patient organizations mobilize those directly affected by high costs in medicines. And other folks mobilize their communities, their governments, and folks who actually see the direct expenditures day in and day out. And that's the only way we beat large trade associations and others when it comes to these policy changes. And of course, incredibly good litigation and incredibly good teams fighting as attorneys and folks pushing this through, along with justices that we trust to uphold the law. At this point, we're in a state where we have to look at what we can do at the state level, what kind of innovation can work. And the last time we did this, we ended up with that entire slate of tools that we just heard from our friends at the O'Neill Institute about, that we can really see moving forward. And it's not without challenge, but I'm really excited to look at what's possible as we go. That's where I'll leave it.
Slide. Thank you, Justin. So I'm Caroline. I'm Caitlin.
I'm Yassine.
And we're the team from the IPIP clinic here at Georgetown. And as Justin previewed, we spent the semester working with UAM and we developed what we titled the Licensing Accessible Biomedicine Act, also known as the LAB Act. And it's a piece of model legislation aimed at reducing prescription drug prices in Michigan. Next slide. So I'm going to start off with a description of the problem and why we chose to intervene at the point we did and why and how we did. Caitlin is then going to discuss the LAB Act's provisions, how we came to decide on what elements to include, and the intended effects of each provision. And then Yassine is going to provide an overview of sources of political support and opposition that we anticipate for the bill, as well as some constitutional challenges that we think might be brought against the LAB Act. All right, so we want to begin by providing a broad overview of the problem we sought to address and how we came to decide how to address it. And as Sheila called your mind to, the broad problem is that drug pricing in the United States is prohibitive for many people. To demonstrate this, we're going to show you a couple statistics. So a study last month found that 60% of Americans take one or more prescription drug on a regular basis, with 25% of them taking at least 4 prescription drugs on a regular basis. On an individual level, many Americans are priced out of access to medicine, with 3 out of every 10 Americans unable to take their medications as prescribed as a direct result of the cost. These effects are especially magnified for those in marginalized communities, as exemplified by the fact that 42% of Latinx people in the US report being unable to take their medications as prescribed due to the cost. So to begin, we decided to look at the drug development life cycle to understand the process and identify an intervention point. One thing that really stood out to us was that the drug development process is very lengthy and expensive, with the average total cost of taking a drug through the entire life cycle being $2.6 billion. We also noticed that the drug development life cycle is very fragmented, with research institutions doing the bulk of the drug discovery, development, process, while pharmaceutical companies supported by the National Institutes of Health doing the clinical research, FDA approval, and drug manufacturing steps. Next slide. So as we look to identify an intervention point, we first zoomed in on the molecular development stage, and we noticed that the work here is largely done by researchers, often in publicly funded research institutions. At the start of the research process, researchers evaluate molecular compounds to identify a target molecule that they would like to produce a pharmacological effect in. Researchers then move to design and synthesize new molecular compounds that are going to interact with that target molecule to produce an intended effect. This is where the difficulty of drug development becomes really clear. And for every 10,000 compounds that are tested at this stage, only about 10 to 20 are going to move on to the next stage. Next slide. So once the researchers have identified a molecular compound with the desired pharmacological effects, they're going to file a patent on it, which is going to give them the right to exclude others from manufacturing that compound. Once a patent has been granted, research institutions are going to begin to look to pharmaceutical companies to license the drug candidate. This is when the research institution and pharmaceutical companies engage in what is called technology transfer negotiations. And the technology transfer point, we believe, offers an opportunity for intervention because it is a voluntary contract with negotiated terms. After realizing this, the Lab Act started to take shape, and we thought that maybe we could include provisions to ensure affordable access within these technology transfer agreements. But once private industry acquires the licensing rights and brings the drug onto the market, the right to exclude granted to them by the patent allows them to set the price as high as they want. And the key problem here is that the public is in effect paying for the drug 3 times. They pay for it the first time when their tax dollars fund the public university research through state and federal taxes that fund the NIH. They pay for it a second time when their tax dollars fund Medicare spending on the drug. And they pay for it a third time when they actually need to use the drug themselves. So before we dive into the specific provisions of the Lab Act, we wanted to provide a little bit of context as to why we decided to pursue a state level effort and why we chose Michigan to pursue that. So we decided on a state level effort as opposed to a federal effort because public universities are governed at the state level and because it is much easier to get small scale buy-in first. And in an ideal world, we see Michigan having a lot of success with the Lab Act and then other states being encouraged and adopting it for themselves. We want to emphasize at this point that we're not saying to do this instead of federal action, but rather in tandem with, and as Justin previewed, right now it seems to be a very important time to look at state level actions to identify what we can do given the changes that are coming in January. We decided that the state level effort was going to be specifically effective in Michigan because Michigan has a history of public pharma and also has dominance in the public university field. So Michigan, throughout the 1900s, Michigan had a successful run with public pharma, which is a system of state-owned institutions developing, manufacturing, and distributing biomedicines at a low cost. So Michigan's public pharma system originated from the diphtheria antitoxin and a shortage of that, but it was so successful that it was expanded to allow Michigan government to produce and distribute a very wide range of medicines. While public pharma in Michigan died out in about the 90s, there's actually right now a proposal on the table to revive it in Michigan and use public pharma to produce insulin. We are hoping to use this legacy and the current movement to bring back public pharma in Michigan to garner momentum for our Lab Act and hoping to identify supporters there as supporters for our bill. And the second reason we chose Michigan relates to the sheer dominance of the University of Michigan system in pharmaceutical research. In 2024, they received over $728 million from the NIH just for research funding. And they are cited as the largest academic institution contributor to FDA-approved new molecular entities with 7 FDA approvals in the last 5 years. And now Caitlin is going to go into the Lab Act and talk about the exact provisions and why we included them.
Next slide. So like Caroline introduced, we this semester have drafted our model legislation, the Lab Act. Next slide. So the Lab Act is a model bill that we designed to ensure that medical innovations being developed at Michigan's public universities are being licensed in ways that promote affordable access to both local and globally underserved populations. So the Lab Act was actually built upon a draft bill that was created after the University of Michigan's chapter of UAEM partnered with university administrators to discuss the need for more equitable licensing practices in the university's tech transfer office. So our model legislation attempts to strengthen this draft bill by incorporating enforcement mechanisms, creating a stakeholder council, and introducing incentives to encourage compliance. Next slide. So we had 2 primary goals while we were crafting the Lab Act. First, we wanted to ensure, obviously, that medical innovations developed at public universities are affordable and accessible to everyone who needs them. But then we also wanted to improve the mechanisms that are available to hold universities and licensees accountable when they fail to promote affordable access. Next slide. So to achieve the first goal, the Lab Act creates specific requirements for universities, the tech transfer offices, and licensees to promote affordable access. Slide. So for example, when a university and a tech transfer office enter into in a pharma company into a tech transfer agreement, the Lab Act requires them to either create an affordable access plan or submit a petition explaining why one is not necessary. And the Act also defines what must be included in these affordable access plans with two key requirements. Next slide. So first, the Act specifically requires that the plans promote affordable access for both globally and locally underserved populations. And this is unique to the Lab Act because many affordable access plans prioritize promoting access to medicines in low and middle income countries, which is extremely important, but it can also leave locally underserved populations vulnerable to accessibility problems. Next slide. So second, the Act requires the plans to include specific strategies, timelines, and measurable goals intended to support affordable access to the innovation. Next slide. So with these elements in place, it's easier for enforcement bodies and the public to determine whether the university and the licensee are maintaining their commitment to affordable access. And so it improves or it furthers both goals. And another way the Lab Act improves accountability mechanisms is by requiring transparency throughout the tech transfer process. So throughout the Lab Act, there are several transparency, publishing, and reporting requirements aimed at improving the accountability mechanisms to hold universities and licensees accountable. For example, next slide. Yeah, one provision requires tech transfer offices to make available to the public either the final technology transfer agreement in full or at least make public the relevant affordable access language. So that sort of aims to solve the problem of like trade secrets and those obstacles by allowing them multiple options for what they can make public. So the goal of these requirements is to allow the public to be as informed as possible with regards to the tech transfer process. Next slide. Because when the public is informed, they can hold universities and licensees accountable for their actions that contribute to the access to medicines crisis. And as we've seen in the past, public pressure can be extremely effective at sparking this change. Next slide. So on top of what Justin mentioned, another great example of this is when UAE students convinced UCLA to adopt socially responsible licensing practices after Xtandi, which is a prostate cancer drug that was developed by UCLA researchers, was being priced so excessively that thousands of cancer patients across the US were not able to afford treatment. So an additional mechanism for improving accountability is our march-in provision. Next slide. So inspired by the Bayh-Dole Act, which is for federally funded research, our march-in petition allows the state to march in when a drug is not being made available to the public on reasonable terms. And the state can either retain the IP rights for themselves or they can transfer them to a responsible third-party applicant. The possibility of losing these valuable IP rights serves as a strong deterrent for universities and licensees who are seeking to circumvent the Act's requirements. And also, unlike the Bayh-Dole Act, the Lab Act specifically requires that cost and availability are among the factors considered when determining if the drug is available to the public on reasonable terms. Next slide. So the Lab Act or the march-in provision also includes a forgiveness clause. This clause allows universities and pharma companies to regain these IP rights if they take the steps necessary to remedy whatever they did or didn't do for the state to march in the first place. This clause rewards the parties for their efforts to promote affordable access while also leaving the door open for future march-in petitions, which encourages them to continue these efforts. So in addition to the forgiveness clause, the Lab Act also creates several tangible incentives to reward universities and licensees when they comply with the Act. Next slide. So first, universities are incentivized to comply because by doing so, they're eligible for financial grants from the state. And then in addition, industry partners are incentivized to comply with the Lab Act because by doing so, they're eligible for benefits such as rights of first refusal, access to pooled funding, and preferred vendor status. So ultimately, these rewards further our goals by creating a win-win scenario. Universities and licensees get these rewards, and then the public gains affordable access to the medications they need to survive. And while these provisions are great in theory, they are essentially useless without an unbiased, independent body to enforce them. Next slide. Which brings us to the Lab Council. Next slide. So with members drawn from a variety of stakeholders, including drug manufacturers and university representatives, the Lab Council was created to provide unbiased oversight over universities and licensees with regards to their compliance with the Lab Act. So the council plays several key roles in the Lab Act. Next slide. Yeah. So first, going back to the affordable access plans I mentioned, if a plan is put into place, the Lab Council is responsible for evaluating the licensee's compliance and, if necessary, making recommendations for how they can further promote affordable access. And then on the other hand, if a licensee files the petition claiming that a plan is not necessary and or feasible, the council is responsible for determining whether or not this is true. And if the council decides that a plan is necessary and feasible, then the licensee must provide one. Next slide. Yes, next slide. Next slide. So in addition, when a marching petition is filed, the Lab Council has two main roles. Next slide. So first, the council is responsible for reviewing the petition to determine whether or not the drug is being made available to the public on reasonable terms. And if they determine that it's not, that's when the state is able to exercise the margin rights. And then, if the state does exercise these rights and the university or licensee submits the corrective action plan under the forgiveness clause, the council is responsible for reviewing this plan and determining if it's sufficient to meet the Lab Act's objectives. Next slide. Finally, the council is responsible for evaluating whether universities and licensees have upheld their commitments under the Lab Act. And if they determine that they have, the council is responsible for distributing the rewards that I mentioned earlier. So by recognizing and incentivizing these affordable access efforts, the council is promoting a continuous cycle of reinforcement. Next slide. Like I said, we drafted the Lab Act to, number one, promote affordable access to essential drugs that are being developed with public funds, and to improve the accountability mechanisms for universities and pharma companies who create, license, and sell these drugs. The Act, which we're very proud of, has very robust provisions that, if enacted, we do believe that it'll greatly contribute to UIEM's fight against the access to medicines crisis. However, as our colleagues described previously, we know the road to enactment is not going to be easy. And as Yassine is going to explain, we are prepared to overcome these challenges.
Thank you, Caitlin. My prognosis, we're just gonna be talking about the viability of the Lab Act. And with any legislation, there's two hurdles to overcome, right? There's passing the legislation and there's surviving the constitutional challenges, which talks about. So I'm gonna be going over all of that. Next slide. So good news. If anybody, good news. If anybody needs good news for whatever reason, there's some good news here. Drug accessibility has a lot of momentum behind it right now, bipartisan momentum. Nationwide, as actually our O'Neill colleague showed, I mean, while it was a map of places where challenges are happening, it was also kind of a map where there was significant public pressure for drug accessibility. It's good news that the people want this, and it's good news that it's bipartisan, for whatever reason. Drug accessibility has been a major priority for both parties and in both chambers of the legislature in Michigan. There's been partisan disputes over how to lower drug prices, but it's got momentum behind it. Governor Gretchen Whitmer, she made a drug accessibility, one of her signature issues. She made a drug accessibility task force in 2020, and they went all of 2020. I guess they had nothing else to do, and they made this giant sort of task force proposal that included things like public production of insulin and even public pharma, but also like less radical measures. So there's political excitement behind it. Even Representative Kurt Vanderwall, a recently reelected Republican, has been pushing for public, he actually passed public creation of insulin. So there's a, Governor Gresham Whitmer hearts drug accessibility. And, we also talked a little bit about PDABs. We heard from our colleagues about PDABs in different states. There's been a broad coalition in Michigan of different advocacy groups that have pushed for the PDAB legislation and other similar legislation. It kind of speaks to the different marginalized communities, especially that sort of benefit from drug accessibility, but also just the wide variety of stakeholders who have reasons to sort of slide their chips in behind a bill like this. First, we have groups like retiree advocacy groups, AARP Michigan. We have the Michigan NAACP, who's spoken out for drug accessibility measures like a PDAB. We have Equality Michigan, LGBTQ advocacy group, which has also come out in support of PDABs. And finally, we have, we have medical practitioner groups as well, like the Committee to Protect Healthcare. Different organizations also like the American Medical Student Association, the Committee to Protect Healthcare, UAEM. And then finally, there's unions. Unions come out in support for drug accessibility measures all the time. It's a solidarity thing. So you might see AFL-CIO or SEIU put their weight behind measures like this. And speaking of unions, I think one of the most promising routes for advocating for the Lab Act is the Graduate Employees Organization at UMichigan. They are one of the oldest and most successful graduate student unions in the country. They've been on strike since like the 70s. I don't know if you've seen the news. There's always something with them. It's great. But specifically, their Solidarity and Political Action Committee has been really effective at building ties with other unions and other advocacy groups kind of across the country. They've done solidarity strikes. They've done other direct actions. They put things in their contract around healthcare. So if I were to hypothetically be pushing for this bill really hard in Michigan, they'd probably be the first people I'd reach out to, specifically researchers within that union who have reasons to both be sort of sympathetic to the Lab Act, like getting their research out to accessible medicines as fast as they can, right? But also people who are in labor and have solidarity with labor. They're the type of stakeholders you want to win over, because then you have access to the Solidarity Committee's network, which then sort of, you can see the slide sort of flow that direction. Unions in Michigan are actually hugely influential to the Democrat Party, but also the Republican Party. It's an important group to win over. So if I were supported, that's how I support it. Next slide. Obviously, there's other stakeholders that would need to be more persuaded, but I think everybody's winnable. I think this is a winnable bill. I think everyone should want this. So, I don't know. Obviously, the pharmaceutical industry might have some issues with measures like this. They sort of fight restrictions on their market power as much as they can. There's also this strong venture capital investor scene in Michigan life sciences. They pay a lot of attention to what's going on at universities, and they put a lot of money and time into what's going on in universities. But the biggest sort of thing to consider with groups like Big Pharma or investors is not that they employ or what the personal opinions are, but they exert significant lobbying power. And so being able to sort of untangle that lobbying power would be an important thing to do for advocates of the Lab Act. Another group to consider here, which is slightly different, is patient advocacy groups. Patient advocacy groups often speak up in support of people who have rare diseases that are hard to find treatments and cures for. And they mirror a lot of the language of big pharmaceutical companies because, a lot of times they're funded by big pharmaceutical companies to sort of mirror this language. But another reason is that they have in sort of earnest point. There's not much of a market demand for cures if your disease is really rare. So you kind of rely on the profitability of other drugs or even the drugs they need to be able to fund the R&D to find new cures where there's no market demand. Thankfully, as we've talked about a lot today, public institutions also do a lot of that research, and this is not an unwinnable group. In fact, there's strong reason to believe people in these groups would want to favor public research, especially with accessibility requirements. Next, a group to pay attention to is the Michigan Chamber of Commerce. They are one of the most effective state level lobbying groups in the country. They have 3 separate political action committees, each one with different donor profiles. I think for legal reasons they do that, but they exert a lot of influence on Michigan's legislature. They would sort of fight a lot of things that look like market interventions as just a patently free market group. However, they also have a committee that is exploring lowering drug prices in Michigan because of its effect, like the downstream effect on employers. they represent about like 5,000 small businesses, and lowering drug prices is actually a priority of those small businesses too. So again, yes, they might have reasons to be like, this is a market intervention we don't like. They also have reasons to go for legislation like this. Now, finally, UMichigan's tech transfer office and other tech transfer offices in the state, Innovation Partners at the UMichigan, they build significant relationships with pharmaceutical companies and venture capital, and their whole job is to make partnering with the university look financially advantageous, and they do a good job. Most of their programming is about the university removing barriers to commercialization. And so the Lab Act might be taken as voluntarily adopting barriers to commercialization or barriers to profitability. They might resist a policy change then that sort of undercuts their job, right? At the same time, in the mission statement of UMichigan Innovation Partnerships is the stated goal of making UMichigan innovations accessible to the public and benefit the public, and facilitating that sort of like quickly. So again, while it looks like a commercialization problem, at the same time, the mission statement behind UMichigan's Innovation Partnership shows another reason why they would support legislation like this. All right, next slide. Now, this is a completely constitutional piece of legislation, and anyone who says otherwise has an agenda. We do anticipate 3 potential ways to attack the Lab Act as unconstitutional, and we've heard a little bit about these. The first might be the takings clause. For the like 2 non-law students in here, I guess, yeah, however many. The takings clause is that the Fifth Amendment says government can't take property without just compensation. Now, patents have been found to be property for the sake of the takings clause a few times. It is generally a weak argument. In the context of the Lab Act, you might make it about the march-in requirement, the march-in provision, but we have ways around it. Secondly, another avenue might, yeah, trust us. Ours is close to the best. Another avenue might be the Dormant Commerce Clause, which we've also heard a little bit about. The idea here is that Congress explicitly regulates interstate commerce, so implicitly, any state action that regulates something like the market outside of the state would be extraterritorial overreach. Now, our legislation has a council overseeing equitable access to IP across the nation and also like worldwide impacts. So it could be taken as extraterritorial in some ways and be framed as a violation of the Dormant Commerce Clause. At the same time, we have recent litigation as recent as 2023 saying that Supreme Court doesn't really see ripple effects on the market is the same as a violation of the Dormant Commerce Clause. So we do feel more comfortable with the Dormant Commerce Clause implications here. And finally, some might argue that the Lab Act is preempted. Preemption is when state law is invalidated because it somehow conflicts with a federal law or the objectives of a federal law. In 2007, the Federal Circuit set a precedent that a DC law regulating the prices of patent medicine conflicted with the objectives of federal patent law, which includes incentivizing R&D. We got a good breakdown of this during the earlier presentation. We also have good reason to believe that the Lab Act could get around this. Again, we can go into this later. Next slide. All right, QR code. Okay, we called our model legislation the Lab Act because drugs are developed at labs and also because licensing accessible biopharma. It's just a FIRE acronym. Here at the IFIPS clinic, we love FIRE acronyms, but also because, as we heard earlier, states are laboratories of democracy. So we think that state stewardship of IP developed at public universities is a great way to work around the roadblocks to patented drug accessibility. It could also problematize those roadblocks and set the stage for even stronger public sector interventions in Michigan around drug prices. The task force report I talked about earlier has a laundry list of different legislative things. Like there'd be hurdles, especially around patents for patented drugs, to get a lot of those things accomplished. So an intervention like this sort of sets the stage by sort of showing what will happen. But it could also be a model for other states looking to leverage their university's research into increasing access to prescription drugs. Ultimately, though, it's not just us. It's up to you too. You'll see action items on the the one pager, the bottom of the one pager, we have them printed out here, and it's also, if you open the one pager through the link tree on the QR code, those action items give you ways you can advocate for legislation like this. Look, public interest in drug accessibility has been a great impetus for legislation like across the country right now. But the more specific we can be about the interventions we're calling for, the better. The Lab Act is exciting because it presents a full program for commercializing research with patient accessibility in mind, as Justin said, from the start. However, it's going to take more than just UAEM. It's going to take more than just the four of us. And so we hope you share our enthusiasm and excitement. Next slide. And we're open to questions to talk about it more.
Wait,
What's up?
we're going to the Q&A panel,
Yeah, that's what I'm saying.
not us.
Oh, yeah, the Q&A panel.
Not on.
Yeah.
Are you moderating?
Oh, yeah, I am moderating. I don't have a chair.
He's a moderator right over there.
All right.
You can carry the chair. Team, do you want to? Get the full.
All right, joining us is also Professor Shravi Kumar, supervisor at the clinic. Yeah, and genius of public pharma. And I'll be moderating Q&A, but yeah. If anybody has any, I mean, we can also just go out too.
Can you flesh out a little bit more about the workarounds to that final problem that Yassine alluded to with the legislation of the Lab Act? Like, how do you get around some of the constitutional problems? We heard a couple of solutions, but there are still some questions remaining given the robustness of the O'Neill presentation about like how not just the volume of constitutional challenges, but the viability, right? These are being punted at summary judgment, not motion to dismiss. So there's something going for them, right? At least they aren't on a motion to dismiss stage, but they're getting into those advanced stages of litigation. So what are some of the other strategies that we might be thinking about around those workarounds?
Yes, yes, I can take this.
Yeah,
Okay.
please.
So one of the,
That was for you, sorry.
I think one of the most important workarounds, for margin rights being a potential taking. Oh, by the way, we stop the recording.
Person who was recording.
At least I got my really good question now.
Yeah.
Yeah. Like the people watching will be like, wow, I'm so reassured that they are about to handle this.
That's
actually a really
good
point.
Yeah, the Q&A is not gonna be recorded so that everybody feels comfortable asking questions. So I will answer as soon as we turn off the recording.
It's a great first question, just like the easy one to start. No, I'm just kidding.
How do you fix the government? Is really the question I'm asking.
Not too much about the elections, the Zoom people that's listening.
Elections.
No, they would be right up there with the fence, they go together real bad.
This would be a great time to get some fruit and cheese.
That's crazy. You're so right.
I didn't know if the trouble was with the recording.
We don't. Pharma companies listening, you should.
Wrong.
We do want from a company listening. We want them to hear that the recording comes out and
Good old
exactly
Ron
when we
Bill.
have all the solutions. That
Good old
was the
Bear.
ready for us, but not ready.
Exactly, not too ready.
You know, it's been on like a show trip.
Okay, sorry.
Right? It's on psychedelics for sure.
Like that?
Why would you?
Five.
Really good.
Yes.
All right, we're ready to answer these questions.
All right.
It still says the meeting though.
So I think,
Yeah, figured out a workaround,
Yeah.
sounds like, so we'll be okay.
so I think probably the best solution to the takings challenge, as asserted against the exercise of margin rights, is to potentially include, clauses